CodeX group meeting. We have three speakers, actually four speakers lined up today for the presentation. Yeah, first I think it would be good to get to hear from you online if you can hear us, because sometimes we have audio problems. Can you hear us?
We can hear you very well, thank you.
Wonderful. Great.
Yay, thank you.
All right, so yeah, we have Professor Marco Lippi of the University of Modena and Reggio Emilia, and Dr. Przemysław Palka of the European University Institute will be our first speakers. They will talk about their Claudette project, the automated clause detector project, which will be very excited to learn more about. They will be followed by Professor Lawrence Leff of Western Illinois University. He will talk about a couple of different projects, including his work on an expert system that manipulates facts as XML documents. And then we were also supposed to hear from Rory Pilgrim, who's going to be joining us from Australia. He's not online yet, and it's still, I think it's very early in Australia, so he may ultimately not be able to join us. But before we get started, and we're picking up some background noise from someone.
Yeah, we got rid of that.
Okay, so Susan's fixed it. Thank you, Susan.
Mm-hmm.
Are there any announcements or news that anyone would like to share with the group? No? And if you want us to hear, you have to unmute yourself if you're online, or you can also use the chat function. But yeah, if there are no, so my standard announcement is that Future Law is coming up. We have 3 more weeks to go, and a lot of people registered already. I think we'll sell out again this year. So hope you can join us for Future Law. All right. So with that, I will turn it over to our first speakers, Professor Lippi and Dr. Palka.
Thank you, Roland. Thank you very much for this. Buongiorno a tutti. We greet you from Florence in Italy. Let me quickly get this full screen. Can you see our slides?
Not yet.
Okay, then.
I think
there is a bit of latency.
You have to select PowerPoint or whatever. Now we can see it. Perfect.
All right. Can you hear us well?
Mm-hmm.
Yes.
Okay. Just in case there's something wrong, please let us know, and then I guess we can proceed. Once again, thank you very much for the invitation. Speak to your group.
You're a little bit soft. Could you speak up a little bit?
Of course, yes. Thank you for the opportunity to speak to you. My name is Przemysław Palka. I'm joined by Marco Lippi here. I'm a lawyer. I'm working at the European University Institute in Florence, and Marco is an engineer, expert in machine learning, natural language processing at the University of Modena and Reggio Emilia. And today we'll be presenting you a project called Claudette, Automated Clause Detector, on behalf of the whole team. Some short introduction. The aim of the project is to automate legal evaluation of terms of service of online platforms and their privacy policies using machine learning and natural language processing. Why do we want to do that? It comes from a certain puzzle, which is, given that consumers usually do not read documents that they require to click, they read and they accept, the legislator in European Union has put forward certain regulation on what can and what must and what cannot be put in these documents, consumer contracts and privacy policies. And the law gives competence to public bodies and NGOs to scan and see whether publicly available documents actually contain unfair clauses. If they do, these bodies usually have competence to make the business stop using them, using different legal instruments. And yet our empirical research has shown that business are using them en masse. In almost all terms of service and privacy policies we have analyzed, there are clauses which are unfair under European legislation and should not be there. There are reasons for that, but one of them is that these bodies that have the competence to control usually are poorly funded, don't have many people working for them, have certain limited factual capabilities. And so our idea is to create technology that on one hand will increase the efficiency of their work, but by allowing them to automate a big part of the legal analysis. And on the other, lay foundations for empowering the consumers through different types of tools, apps, or browser extensions that we'll tell you about shortly soon. Very briefly about the law, what we would like to state is that EU consumer law has part that is contractual and regulates terms of online services, and this contains prohibition of using so-called unfair contractual clauses. The law itself contains a very vague and general stipulation which says that clauses that create imbalance of rights and duties between the and this general clause got concretized by several judgments of European Court of Justice in Luxembourg, which is sort of an equivalent of the Supreme Court in the United States. So there is legislation about terms of service, consumer contracts and terms of service. And on the other hand, there is EU data personal protection law, which soon will transform into GDPR, General Data Protection, which given its extraterritorial application will also be of interest to lawyers of American companies that direct their services at European consumers, and it puts forward certain standards for processing of personal data, and these standards should, at least in theory, be reflected in privacy policies. So the bottom line here, without getting into detail, is that there are specific requirements about what clauses should not be there in terms of service and in privacy policies, and yet our empirical research shows that they are used there. So what do we do in the project is we download and actually read these documents. So we read them, and then we actually read them, though in our professional capacity. We tag the potentially unfair clauses in a way that allows machine to learn to detect them in new documents. There is one question about why are we tagging only potentially unfair clauses, and there are two reasons for that. One is that often we might be able to argue that a certain type of clause is unfair, but until we get a judgment from ECJ in Luxembourg, it's not really that we know that it's unfair. But for a lawyer who is trained in these organizations, it's usually good enough to have it highlighted. And on the other hand, sometimes extra contractual, extra textual circumstances might be relevant here. Here you can see a list of the services of which we have covered. So we read terms of service of all of them and tagged the potentially unfair clauses to show you more or less how this looks. This is a small excerpt where you can see that we are reading the entire contract and then tagging the clauses which are potentially unfair. The tag contains two types of information. On one hand, the type of potential unfairness. Here you can see a right to unilaterally change the service or the document. And somehow called contract by using clause, which says that simply by accessing the website, you accept the terms. And then you can see the number, which can be 1, 2, or 3, which indicates whether, according to law as it is now, it's fair, potentially unfair, or definitely unfair. And I'll pass it to Marco to talk about the method quickly.
Yeah, to give a few details. So from the machine learning point of view, the task was formalized as a sentence classification task. So positive sentences are those containing potentially unfair clauses, and negative are all the rest. We tried out a few very classic algorithms for NLP used for text classification, so support vector machines with bag of words. We also tried some deep learning methods, some, I have to say, basic deep learning methods, so convolution networks and LSTM networks, again, for text classification. The interesting thing is that the best performing approach was structured SVM, so in particular SVM HMM, which exploits bag of trigrams, but it is capable of taking into account the sequence of sentences. So basically it performs collective classification by jointly assigning a label to each sentence. And this is the table of results that we got. So using our corpus of 50 documents with a typical setting of leave one topic out procedure. So we, in turn, each document is the test set and all the others are the training set. And with SVM HMM, we achieve 0.73 of F1. And you can see that the deep learning approaches here perform a little worse. So using the n-grams is really a strong baseline. But again, we have to say that there's still a lot of the things we can try with deep learning approaches. We would like to try also bidirectional STM, attention models. There are plenty of things there that we definitely would like to try. So another thing we would like to share with you is that we prepared a web server where you can copy and paste some piece of text of terms of services that you can find online and submit it to our CodeX system, and you will get results. So our system will highlight the potentially unfair clauses according to her, to Claudette. So the system will also try to categorize the unfairness of the clause. So this is again done with a machine learning system with an SVM, multi-class SVM. I'll pass to Przemek for the conclusion.
Right. So to one comment about the percents, it might seem not that very impressive what we have with 73% general average accuracy at this point, though we must say it's usually increasing by 5% with each 20 additional items we added to the text. So we hope to get it to the level where it's actually operable pretty soon. And we're also thinking of making some merger of this particular method with other methods, maybe grammar methods where they can vote against each other. And so to quickly say what are the possible uses of the technology, to reiterate, because from what we have seen, you also have certain corporate speakers at your groups. We are not being a company here, we're just researchers. So this is first and foremost a research project, but we think that this technology can be useful in many ways. On one hand, increasing the efficiency and quality of enforcers' work. You can see the 12% digit, which is the amount of clauses that are potentially unfair. So if you have big amount of text that is unstructured, we are able to deliver structured text that shows lawyers what they should pay attention to. Then we also think of automating of enforcement pyramid when it comes to monitoring the terms of service. We actually also are thinking of putting together a crawler that will go around the web and scan the terms of service that are there, maybe inform the enforcers, maybe inform the business that they should do something. And on the other hand, we can create some apps or browser extension to increase the awareness of the consumers. Maybe they will still not be able to negotiate it, but they're able to, make some noise, write on Facebook, hey, this is unfair clauses in Facebook terms of service. And the ways in which this can be used are many, and we're sort of trying to leave it open for people to comment. So this is basically all we wanted to present you. If you have any suggestions or criticism, or if you ever experienced similar projects, we'll be very happy to hear from you. And also if you have any questions or comments, we're more than happy to answer. Thank you once again for the possibility to address you.
Thanks a lot.
Great, thank you. So I think this is super cool, and I think almost the sky is the limit of this kind of work. I think one thing you've addressed in your kind of closing sentences is, well, what is kind of the use case for the consumer, right? And in a sense, you empower him to identify unfair clauses, but how can the consumer then really have any, with this kind of imbalance of bargaining power, they won't be able to renegotiate the Amazon terms of use or privacy policy, right? So in that sense, it's almost more of a tool that you could, be more useful to like consumer protection groups and that sort of thing, that you can empower them with this kind of with these kinds of tools. For consumers, on the other hand, you might use the same techniques that you were using to identify those unfair clauses, but instead find clauses that give some immediate kind of ability to act to the consumers. So it might be return policies, it might be, things that, that are actionable for the consumer, right? When you see, okay, or when the warranty expires, things like that, right? And that you might not have those terms in terms of use, but in other typical kind of corporate agreements, right? Where you can use this machine learning approach then to extract the clauses and then make it actionable for the consumer. That the consumer then sees, oh, okay, the warranty on my car is about to expire, and I should act now. Things like that, right? Or or if you get what I mean. So I think that's a little bit, I know you're not thinking about commercial use cases because you're more sort of doing the basic research first, but I can see this approach kind of being leveraged for a lot of potential commercial use cases for individual consumers. So I think that's very cool. So this is more a comment than a question, really. Are there anyone else has any questions?
I could ask a question. You had that sample set of like 50 terms of services. How many issues or like potential issues you found from them? Do you have like statistics on that? Numbers in that? How many like issues you found from those 50 sample terms of services that you went through? Oh, sorry.
It's the corpus size is about 10,000 sentences.
Oh, okay. Okay.
So it's not that big, but it's also not that small anymore. And usually each of them contains at least 5 types of potentially unfair clauses. So it actually differs. You can see that the companies who are incorporated in Europe usually tend to have less of them, or if there is a filial of a company in Europe, then they usually get some comment from a European law firm and they have less of them, but they are still recurring quite often.
And 10 to 12% of sentences are actually positive examples, so potentially fair clauses.
Interesting. Thank you.
This is really fantastic consumer protection machine learning software. Thank you. I'm curious in the big picture how you think of, say, all 28 countries in the EU and their languages and even voice ahead. Is there planning for that at all in your thinking at this point in your remarkable coding?
Thank you. That's actually a very good question. So there is clearly the problem of language, and there is also a problem of, since unfair terms are regulated on the level of the directive, then nation states or states have certain discrepancy on how exactly they want to implement that. So there is also local law problem. What we are doing, we had a meeting with consumer organizations from around Europe to test whether they're interested or not. So basically what we're trying to do is we're making a proof of concept that this works, but then to have it work for any other language, we do need to create large enough data set in that language. We probably as researchers won't be able to do that since we happen to speak Polish, Italian, and English. That's what we can do. However, a lot of actually from the services that we have scanned, only the ones that heavily rely on intellectual property, so YouTube, Vimeo, tend to have different terms of service for different countries, while all the rest retain the same and either have them in English or have different language versions, but it's the same document, and if they contain the clause that should there be a conflict, the English version is the main one. So there is definitely space for language diversity, but I think already on the level of English, given that many of them come from the United States, we can already have some actual action.
This is Susan. I mean, just a thought about where you go with it. I mean, if there is any jurisdiction that allows you to make a claim based on some of these clause violations, maybe there's a business model that could be built around that in a jurisdiction. Just a thought.
Thank you. That's a good point. I think in personal data protection, there is basically since 25th May, we'll be able to make a claim in every jurisdiction. Now, whether whether it's privately used or if it's used for somehow facilitating compliance by NGOs, that's a certain choice to be made. But yes, thank you for that.
Mm-hmm. So what's your next step for your project?
So right now we have concentrated mostly on terms of service and so consumer contracts. With GDPR coming into force on 25th May, we want to concentrate a little bit more on privacy policy. And the nature of task there is a little bit different, given that GDPR not only prohibits using compare clauses, but also have certain positive requirements on what clauses should be there. And also as a prohibition of vagueness and imprecise language. So if you, for example, expected to state what is the purpose of processing data, it has to be the exact purpose and not mainly this purpose, or among others, this and that purpose. So we might need different technological approaches, but that's where we.
It will probably not be just a sentence classification task. It will be something more sophisticated for sure.
Interesting. Okay, so you said your corpus was 10,000 terms of use and privacy policies, but there was something you had 50 agreements from.
No, so it's yes.
50 companies. So I was confused by it.
Sorry, it's 50 documents, 50 contracts, which boils down to 10,000 sentences.
Oh, sentences. Okay, I get it. Okay, sorry, I was confused about that. All right. Okay. Any final questions? All right. Well, thank you again so much for joining us. This is really cool. Please keep us posted. And yeah, we will turn it over to Professor Leff now, if he's here. And I think you already unshared your screen. So let's see if we can. This is.
Yeah, he's got his up now.
Okay. All right, Marco and Przemysław, thank you again. And let's turn it over to Professor Leff from Western Illinois University. Oh, here you are. Wow. Oh no, that's not him.
It is him, yeah. Hi, Dr. Leff, can you hear us? He's talking, we can't hear him.
Oh yeah, your audio is off. 1 second. Maybe this is on our side.
Okay, can you hear me?
Yeah, now
yes,
we
we
can.
Okay. Okay, I'm going to be emphasizing this, which is a project that I started and had some students with around the turn of the century, since that was what I was led into as well. And if there's time and interest, I could move on to some more current projects, which are essentially unrelated in participatory democracy. And been fortunate to have 3 hardworking students who contribute a lot of that. I'll mention their names here. And this gentleman independently developed the XITE system here, and he's at this company as well. And this system is based on streaming XML models such as SACS. And he's also with that. And one of the things that we applied it to, and this was at the behest of one of my hosts during my sabbatical of that time, Dr. Greenwood of MIT, was looking at the rules of service for a market. So some people like Intelisys might set up a market for purchasing and invoices and so forth, and there might be a standard rule of service, and then that might apply, and then we generate contracts under that master agreement that represent a particular company purchasing a particular set of supplies from a particular vendor. So that process, so we actually have mapping coming here under the control of our master agreement that knows about the XML that's exchanged. So Intelisys and many other firms at that time allowed all the participants in their market to send their XML. They'd be tracked, and effectively they'd be forming contracts by exchanging XML. So each of these represents a contract. And we used an EBXML standard here And one of the interesting things, if you just do classic offer and acceptance, or you look at some of the very first work in AI and law from the 80s, you know, you have dates and offers of acceptances, and did the decline of the offer come in before it was accepted, and so forth, and so on. And those are embodied there in our expert system. And we look at various parts of the XML exchange in order to do that, as we see here. And then we can come back and validate the dates. We also, if there is an issue, we actually check the XML that might be electronically signed against certificates and private versus public keys. And we use the concept of a cyber notary. They are allowed in a few states, although I don't think they've actually taken off in a practical sense. But we can come back and essentially generate a fact that says XML was there, and we have been doing that, and we have a proof of concept that was published. And we can say that not disputed as well. So all that was done, and we demonstrated, and we went completely through some of the XML. And we also, and for those of you who are not familiar with that, with XML, we have an opening closing tag and tagging here. And this is a simple tag that we used in our benchmarks that represents that one person is a child of another, that we could be used in determining ancestors. And one of the expert systems was built on top of Jess as well. And that's an expert system developed in the next state from those of you who are actually for the live part of the meeting, New Mexico Sandia Labs. It's pretty available, at least for those who want to experiment with it as well. And the most obvious thing to do is just simply take every tag from the XML and create a expert system fact. And this stands for foreign keys and one key per XML tag. So we have an XML tag representing this. If this was the XML that doesn't have a parent, well, this does have a parent, and you'll notice this number here matches the number here. And all this is used by the expert system rules to create the operations. Now, obviously, asking somebody to work with the pure Jess at that fact would be too tedious, and one of our students developed a wonderful graphical user interface. And we worked by the same concept of the database by examples that are used now in modern database systems instead of SQL, where we simply just imported the XML representing the contract, and then we can click on here and create the rule. And then there are other tags, so we can click on a part of the document and make that a variable that can be matched in the XML. So we can match that if we want to move that number in some rule to, let's say, create a judgment document. And that would go to another part where we would have to say, did the other person do the consideration? And this gentleman did the benchmarks, and we did quite a few different expert systems and different ways of handling the XML to see when each would be better. And again, we use a very classic expert system rule benchmarking strategy of just finding you have a whole bunch of father or mother and their children, and trying to track down, is this person an ancestor of another? And in that kind of a system, if we have a very long chain, we have lots of useful facts, and every single fact is used in the chain. And we compared two different ideas, that the intermediate facts generating that maybe not the very end of the rule, 120 facts is the rules, but in some cases we actually create XML each time, and sometimes we keep everything in Jest. And we can see that's slow. So we did everything in Jest, just an ordinary expert system without XML. We see we can go up to like 1,200 ancestors, lots of chaining in only 2 seconds, obviously insignificant. We can't even do that if we keep everything in XML, and we're obviously a lot longer. If we use intermediate Jest facts, we can get the time down to a much more reasonable number. Now we compare that to Dr. Callahan's system, which uses SACS technology, and instead of 4,000, we have 986 facts. And then I had one of our students actually just do an XML expert system, just totally independent of Jest or any other tool, and the time was actually considerably faster. But still, and when you consider that we could just do an expert system, and we also tried just using XML technology independent of expert systems, which were 2 seconds. Clearly, working with XML in this kind of chaining, with lots of chaining, was not time effective. On the other hand, in the kind of situation which we envision, which would be a court where there might be lots of documents, and the court just simply wants to say, hey, do we have enough affidavits and so forth to match up so we can declare a summary judgment based upon the affidavits in XML and the facts that have been, the pleadings and so forth. That kind of thing, where we have lots of junk facts that may have nothing to do with the current motion, but the actual reasoning process is very slow, all the times are quite reasonable. And as you can see here, unlike where Excite beat our everything is very reasonable here. And notice that we actually, the chain was only 12 useful facts as well. And remember, these systems are just standard XML technology scripting languages for working with XML, independent of anything with expert systems. So clearly, the expert systems slow things down. Is there enough time and interest to talk a little bit about participatory democracy?
Sure, but maybe people have questions regarding your XML project. I'm a bit.
And by the way, I should mention, apropos the Claudette system, I didn't prepare any PowerPoint for that, but Dr. Greenwood at MIT and myself, all around 2005, published on a system for managing the end user license agreements, or in the kinds of agreements that the previous presenters were talking about. And our approach was different. We basically asked the people promulgating the agreement to mark up with XML. We provided a tool specifically for doing that. And then we envisioned that all the click I agrees would be handled by a standard Java applet. Now, that technology has had some security problems since then. But there'd be a standard Java applet that would pick up the agreements. And one interesting thing is now people sign the agreements, but they don't keep a record of them. And one of the basic things they tell you, as a consumer, whenever you sign a contract, keep a copy of it. And in fact, most people don't do that, just like they don't really read the agreements either. And we recommended and did a proof of concept for a system there. And another interesting issue is to keep in mind in that issue that Dr. Greenwood focused on is that in a big company, people are constantly signing agreements. They want to download some software to use for their project for the company. They obligate the company. The company has no control over that. And no record is kept on a company-wide basis that, Mr. Smith, a programmer, signed some EULA. But anyway, getting on to participatory democracy.
Did you want to take any questions regarding the XML project?
Okay, that might be a good idea as well. Any questions on on the XML work that we've done?
Can you just clarify what sort of the objective was, the overall objective of the project.
The objective in there were actually two objectives in our rule-based work. The first objective was to develop a general XML system for doing expert systems that manipulate XML documents. Also, I was very involved with the electronic court filing documents group and the e-contracts group. And the goal was to have an expert system sitting inside the court, and the litigants would be submitting their pleadings and affidavits supporting their motions as XML, and then certain ministerial activities could happen automatically. There would be just rules that would identify those the documents and say, oh, there's enough evidence, this is a clear-cut case that we can award summary judgment. We have a contract. We have an affidavit that the person performed. We don't have an affidavit that the from the other party saying that they didn't perform. We don't have an affidavit that anybody paid. Therefore we can go ahead and award summary judgment in the amount of the payment clause. That was the goal, and to deal with a certain amount of mass litigation that might occur as rules.
It's a system for mass litigation to help automate.
Right. So,
steps
and then also to implement the. Did I hear another question?
No, that's
and then also, we envisioned at that point there were a lot of purchase orders being handled by these electronic marketplaces that various entrepreneurs set up. IntelliSys was the one that I focused on. And we wanted to provide some way of automating those master agreements, and again, having as part of that marketplace the litigation part. So now when we go to Amazon, if you go on Amazon and you buy from an Amazon seller, there's a connection to UPS or the United States Postal Service to track the package, and that's kind of integrated as an integrated third party. And our goal was to have the court systems be such an integrated third party, so if somebody submitted a purchase order and submitted the goods and they weren't paid the appropriate amount, the litigation would happen just as part of the system, just as now the systems are integrated with the shipping company. So that was the goal. What happened around 2007, I was getting ready for my second sabbatical, and on the legal XML call, I said, I have my second sabbatical. We had a whole bunch of court IT types and on the conference call, and I said, well, I'm willing to come out and do my sabbatical. Let's put the system out. Let's field it. Because we had basically done everything that we could as proof of concept. It was time to field. And, I recognize if we put this in a court system, they're going to be spending a lot of time working with us, even though I'll be doing all the programming. And none of the courts were willing to commit the time where, they said, oh, it's a fantastic idea, but we don't have the time to really work with you. And then I moved on to participatory democracy, my next topic. Okay.
Sounds great. Well, I just see that Rory has joined us now. I still want to talk about
if you want, I can talk a little bit about what we're doing, or if you want to go on the next topic, and then at some future date, I can.
That sounds great. Yeah. Maybe.
Okay, so I'm gonna mute my screen and not overstay my welcome. And
no.
At some point,
Dr. Leff, we have time if you want to give a few brief remarks about your other project.
All right, then let me quickly talk about our participatory budgeting, and we're focusing right now. It's a 16-year project, but right now we're focusing on participatory budgeting. And the ideal there is that we start with, and there are actually 3 systems out there that do number 1. Everybody goes out and they enter their ideal budget. We're oriented towards the federal budget. As you all know, our federal deficits are getting bigger and bigger and bigger. And everybody will enter what they want the tax rate to be on the top 1%, on the middle class, on the relatively poor. And we take all the systems. Now, all the other three systems out there that I mentioned in detail in my papers, but the other three systems out there, that's the end. They take the data, they present the person with what the deficit would be. The person can adjust their numbers like we do if they think the deficit's too high or too low, and then that's the end. That's the end. But what we do is after they enter their ideal budget, is we present every participant with some of the ideal budgets. If we're just doing a small experiment, everybody would rate everybody else's budget. In a larger experiment, where we had thousands of participants, each submitting their own ideal budget, obviously each participant would rate some random sample. And this is a rating screen that we might see. Some of these numbers are a little bit off from when I took the screenshot, but it would display, how much taxes collected, the total expenditures, what the deficit is, what the various rates are in the budget items. And then the participant would choose a number 1 to 10 for each of the trial budgets based on their values. At that point, we simply average those ratings. And those of you who are familiar with the genetic algorithm paradigm, is those average ratings form a fitness. And the genetic algorithm paradigm, the highest rated budgets, chromosomes, or whatever it is that you're using the genetic algorithm for, those kind of come to the top. They're more likely to be selected and crossed over. And in many genetic algorithms, the choices that have very low fitness are just simply eliminated with no chance to be part of the next generation. And then at that point there as well. And then we do the crossover process. In our context, crossover might represent combining, let's say, the tax plan from one highly rated budget with the other tax plan with the budget amounts from another highly rated budget. Now, it might turn out that when those are combined, people may not like that combined budget, maybe because the deficit is too high. And then, so we generate a certain percentage by simply doing the crossover. I'll mention that briefly for those of you not familiar with that. And then we go around and we have a new set of budgets that represent combinations of the old highly rated budgets. And we then ask the participants to rate those, and we can repeat that process. And our simulations and the whole paradigm of genetic algorithms is the system converges, and when we've done our simulations, we found that in fact the system converges as well under a variety of circumstances. And this is an example of that swapping or crossing over. We might take one number here, and notice that this is past this line that we have there. And then it ends up being combined here. So we combine these two, and then the combined one, this 4.3 moves to this set, and the 3.5 moves there. And that's our general crossover process. We also can have compromise events. That's also part of the genetic algorithm paradigm. And I'll mention that in a little bit. And we may just simply copy some elements with a certain probability. Compromise is just simply taking each number and averaging them. We might use a random number between A and B. And if you can think of this as a space in 14 space, and this is 14, another point in 14-dimensional space, that might be any point in the hyperdimensional cube of 14 dimensions. So we just...
Professor Leff, we have to wrap it up.
Okay, well that
one more
really
speaker
is it.
today.
Let me move down a little bit to maybe our simulation results here. So we did. I'm not sure. Okay. Well, anyway, we simulated here, and we looked to see because the participants one of the things that we may have is a manipulator. And a manipulator, let's say if you have a defense contractor who's manipulating, might say instead of just simply voting or rating higher this budget than this one, where this number is slightly higher, might look at this number and see that if they rated this one higher than this one, they would actually give a better preference to it. And then we found that when the people were sincere, everybody, including the person who was trying to manipulate, got a better satisfaction than if somebody trying to game the system a little bit by voting for a system and trying to figure out what the genetic algorithm will do. And this was also true when there were two manipulators and they were just basically engaging in a classic alpha-beta game like a chess game. So we found in our simulation we're about ready to start fielding, and perhaps in a year or two I'll give a talk with some of the results and data that we've collected. So let me turn it over to whoever's next.
Thank you. And how could people, if they had a follow-up question for you, how could they reach you?
I think my email and stuff is there. And one of the things that I've also done is I have longer versions of both of these PowerPoints with voice animation that I shared with Dr. Salkind, and perhaps she could kind of copy them or post them along with the CodeX agreement that has a lot more information.
Yeah, actually, if someone on your end wants to post to our Facebook page, that would be the most expedient. Do you want to give us your email address and I can put it in the chat
yes,
box?
it's MFLLL, that's Macomb Faculty and 3 L's, which are my initials, @ and WIU.edu. WIU is Western Illinois University, my home university.
All right.
Excellent.
Well, thank you very much.
Thank you.
Okay, thanks.
Thank you very much. All right, so let's turn it over to Rory now. Rory, you there?
Let me.
There he is. We have to. Rory, can you hear us? Yeah, we
I can hear you. Can you hear me?
Yep.
Perfect. Awesome. All right. Is that PowerPoint visible?
Not yet, but let's give it a second.
Okay. I think I got to press a button. It's my fault.
All right. Oh, over to you, Rory. We can see it. Great.
Yeah, beautiful. All right. I'll be very brief.
First of all, thank you for getting up because you're in Australia now, right?
I am. I've been
and
fooled by
it's very early there.
Yeah, I was fooled by the daylight savings. It just came in, and all my estimates are out. So, but that's okay. So thanks very much for having me. It's a real honor to speak. And I'll keep it brief. So what I'm talking about today is my honours thesis I wrote a few years ago as part of my legal degree. So it's going to be brief, and I'll just kind of give it a context and some of the ideas that I was tossing around, and then open for questions. So my honours was on a concept of a legal commons, and I'll talk more about that as we go. So a bit of context, in the early 90s, the free access to law movement was spun out of Cornell, and the movement's purpose was to provide free access to primary legal materials. Now this idea was incredibly popular, and it's taken off around the world, including Australia. And primary materials are great, so legislation, case law, it's all very useful, but obviously it's very dense, and it takes a lot of extraction power, which is what a lawyer provides to analyze and apply these materials to a client's individual situation. That's the kind of secret sauce of legal services, which is to take existing primary materials and say, what does this actually mean for you? Computational law is gaining traction in the commercial space in terms of taking shortcuts from these primary materials to legal solutions. And the obvious question is, what's a free alternative? And what's the response from a kind of free access to law movement philosophy? So those kind of thoughts led me to think about the legal commons. which is a thought experiment about how can we provide social production to produce high-level legal informational resources. So legal commons in a nutshell. So it's a theoretical concept. It's not built. It's just some ideas. But it's effectively an informational resource maintained by legal professionals and lay people that's akin to open source software, and it's not unlike a Wikipedia for law. What does it do? I guess there's two primary functions of it, with the first being providing a repository for structured legal data, and this structured legal data would be maintained and contributed by the community, and it would allow for analysis and kind of data science experiments to work out what's the best way of taking this legal data and turning it into solutions, and in turn that analysis could be formalized in a series of legal apps to help produce useful outputs that will be valued by the community and other users. I think the big question that everyone here asks when they kind of hear this idea is, what are the incentives to contribute? So I'll try and go over these. Now, I think, on reflection, obviously I did this thesis a few years ago. I think there are some, this is probably the weakest part of it, and I'd be interested in other people's thoughts on what they think about whether or not there's actually, the incentives are real, but I'll go through some ideas that I did have. I think reputational is a big one. If you imagine that you are going to formalize a landmark legal case into a structured data set, that would be something, if you had the kind of dominant interpretation of that case, that would be very good for your reputation. It'd be akin to having a very highly cited legal paper, and that would be that's a kind of contribution incentive that would appeal to scholars and legal students. Sort of secondary, if everybody's doing this, and this is becoming a widespread phenomenon, law firms may want to get their contributions out there in the public space, so it's very clear that they are experts in a certain area and they own they're the key contributors to a certain space within a legal world, I guess. The second potential incentive is pressure from clients. So clients have an interest in kind of driving people towards a culture of collaboration to drive down lower legal costs. If their lawyers are contributing the legal knowledge that they're paying for to a sort of a free community like the legal commons, it's going to pay back for them in the future, because if everybody to do that and that culture was to come about, sort of everybody would benefit in the long run, at least from a client perspective. Because of policy considerations, governments have an interest in also encouraging incentives to contribute to such a resource. So governments could produce their own contributions, and to an extent, governments already do. They produce legal facts, FAQs already. They produce informational resources. This would be a more formalized and, I guess, hopefully more valuable way of doing that. That could be scaled and contributed by other people. And they could also incentivize private lawyers to actually contribute through a range of policy issues, which are difficult to kind of enforce, but hypothetically possible. And the final point I wanted to make was around what happens if law firms kind of stand still, and there's tech companies who are experts at this legal informatics, and they create these high value resources. This is a threat and a disruption to incumbent law firms, because they suddenly lose the knowledge power that they've kind of had as their competitive advantage for up to now. And my argument is that law firms could see this as a kind of akin to the way IBM sees their business at the moment, which is we provide a free product, so for example, Apache web server or something like that, and we sell services based on that product. So law firms would collectively contribute to this informational resource, but then sell services based on it. That's the kind of model I would say, and it would be defense against tech companies kind of taking that space and taking that value. So there's some ideas and incentives to why people may want to contribute. I think the next question is worth asking is, why does it matter? Why are we even talking about this? So the first one is that such a resource would hopefully reduce legal transaction costs or legal costs in general, which should lead to an increase in academic activity. It's much easier to sign a contract if the legals can be done cheaper. Much easier to do a mergers and acquisitions deal if the legals can be done cheaper. Sort of, you can play this out in a lot of ways, and that would hopefully lead to a better allocation of finite resources. Law firms at the moment all act independently, and they're kind of crunching the same numbers and doing the same thing, and it's terribly inefficient. There's another kind of aspect in terms of inequalities, which is having deeper pockets augments the equality of your legal rights to the extent that if you have more money, your legal outcomes are probably a better place, which is something I think a lot of people would find troubling. It's kind of it's an accepted fact, but it's still one that we should I guess think about and ask why and challenge. And the legal commons I see as a way of potentially winning that fight.
Rory, we have about 4 more minutes left, so I just wanted to see if you are planning to leave some time for questions.
Yep, I am. I've got one diagram coming up, and then I will move to questions. So yeah, I'm very conscious of that, but thank you. So I made this very ugly slide yesterday, so I apologize, it's not very pretty, but it just hopefully gives a bit more of an explanation of what I'm talking about, because I know it's very vague. So what we have here is in the middle there, you have requested legal document or question. So a user wants to produce some output. They consult some sort of high-level legal app, and they get a desired output. Now, from their perspective, that's all they care about. But in between that, there's open source resources that are being leveraged to produce and to support that input-output relationship. So with the legal commons, users are contributing at all aspects. So the bedrock of the system would be structured legal data, which could be annotated and edited by users to say, well, this case means this, and this is how it should be thought about in terms of the structure, sort of that informational processing of existing legal documents, those primary resources, high-level legal apps, which are the kind of the ways that legal data is referenced to produce outcomes. So, for example, a simple decision tree. And then on top of that, open source legal libraries, which are ways of building these apps in more efficient ways. So you could have a template for decision trees within the legal commons, and people could leverage that to build their own kind of custom decision trees for specific applications. So hopefully that gives you a bit more of a flavor of what the legal commons is. I'll skip this next slide and just move to questions. So I know we're running out of time. So please, if anyone has any questions.
I have a question, but I wanted to see if anyone else has a question for me. Anyone in the group here or anyone online have a question for Rory? No. Okay, well then my question is, I think in a sense, the law should be commons from the get-go, right? But we've seen all these commercial players in different countries trying to put paywalls in front of the law, and this is just the English language or the human language law, right? We're not talking about anything structured yet that computers can work with. But I think it would be very difficult, to establish this concept if you don't really narrow in on a particular area. Where you have a specific kind of community that's incentivized to really contribute, and then there's specific utility coming out of it, right? So there are pockets of areas of legal information that are already fairly freely available. If the statutory law, in a sense, in different countries is fairly accessible, but then you have, like, you know, public records information that should be accessible in the US, but that's usually behind paywall, so you have to go through some of the big information providers. Then you have some private players that are already making the case, that do some of what you said with the case law, like case text, for instance, try to make the case law available and assemble a group of experts around it, and in terms of annotating the raw materials. So there's all these little kind of, there's areas of the law that are quite, you know, closed off, and there's and there's areas that are quite open, where there's communities sharing expertise. What's the, so some of it is happening already, some of it is still behind paywalls. What's your specific kind of you know, access point you want to find to this, and in kind of bringing about this larger vision of a legal commons?
Sure, I think it's a great question, and I think the observation that different parts of the law lend themselves more to these communities because the incentives are aligned in such a way that contributions are more forthcoming. That there's already a culture of collaboration and contribution. I think that's a good point. In terms of what's the way forward, I think you're exactly right, where you would take a niche application that's useful and kind of demonstrate a proof of concept and say, well, this body of law, we can produce these apps very easily and sort of consolidate a bunch of legal information in a way that this kind of niche is well catered for, and that could be a proof of concept, and hopefully you could incentivize and show people, well, this is what we've done with this particular area. You know, is that something that you would benefit from? In terms of what a specific area to start with, I think there are a lot of contenders. I guess it's probably, you'd probably want to talk to people who are more willing to share, and they have, like I said, those incentive structures are set up. I haven't actually given enough thought. Very little of what I thought about when I wrote this was about how to start it and what the kind of next steps were. That's kind of something I still need to think about. But I think your observations are spot on, and if you were to do that, you would certainly identify those areas.
Well, I think there's a market for, at least I heard some people in corporate legal departments express a desire for having a neutral, at least a neutral platform to share, like, kind of contract clauses that are computable, right? So that you don't have all these different, or as we move more towards a world of computable contracts, so that we don't have all these, like, organizations that build their own kind of proprietary systems, but there's sort of a neutral kind of language for computable contracts clauses. That goes a little bit in that direction, I think, and this might be, you know, if you kind of get the right stakeholders together, you know, this might actually be one area where you could get some traction for this idea, I think.
Yeah, no, I agree. The problem with trying to establish a standard is invariably you say your standard is better than every other standard, and then somebody else has the something about their own standards. It's quite difficult. But I think there's hopefully there would be something compelling about a standard that was not built from a proprietary perspective, that was open source.
Okay.
I think that's got some real merit.
All right. We're already 3 minutes over our time, but I just wanted to see if there's maybe one more question for Rory.
I could refer him to a couple of resources. So nonprofit community, so Access to Justice in the United States, that community is very robust, especially in terms of forms production for the courts and so forth. And then in your own home country, Guido Governatori, who is going to be with Kate on a panel at Future Law, works for CSIRO, which you may...
Yep. Yeah, you should connect with. Have you met Guido Governatori yet? He's in Melbourne.
No.
He's a good person to kind of talk to.
Yeah.
Oh, that'd be great. If you could put me in touch, Susan, I'd really appreciate that.
Sure. Kate, do you want to?
Sure, I can do that.
Yeah, and he is going to be leading a panel at Future Law, so watch for the Future Law video when it gets posted after the conference.
Excellent.
Yay.
Sounds like a great next step. Thank you so much.
Great, Rory. Thank you so much. Thank you for getting. I don't know if it's a very late night for you, a very early morning.
Early morning.
Early morning.
Early morning. Okay. Well, I hope you have a great rest of your day. Thank you again for getting up so early to join us and present here. And thank you everyone else for joining us, all the presenters, all the participants. And I don't know, Susan, do you have a meeting next week?
We do. We have 3 more presenters next week, and then we are on hiatus after that.
We're going to be teaching our legal informatics class in the spring, and we're usually not running our weekly meetings. So, but we may have every now and then an ad hoc meeting.
We could have a pop-up.
So yeah, look out for our pop-up CodeX meetings. All right. Thank you all for joining us again, and we'll see you next week. Thank you.